Sorry to have kept you.
My lady, not at all. I promised that I would find the references for you to selling as a going concern being better. Forgive me. May I start with the judgment given on the appointment of the receivers? I don't have the evidence in the bundle that was then put before the court, but you will find the judgment in the authority bundle tab B28 in the relevant passage.
Sorry, B28, so...
Yeah, volume 2, I think it is. Sorry. And, my lady, the relevant section is 15 through to 20.
Just give us a moment then.
Of course.
Thank you for that, because that reveals, therefore, why we have specialist footballing receivers.
And indeed, I think it's fair to say, in the application to appoint, their experience was relevant. Why don't I think my friend
The point that Mr. Justice Marcus Smith there is making is that the jurisdiction to appoint receivers, said to be by, quotes, way of equitable execution, was historically because the courts of equity allowed them to be appointed where legal execution wouldn't work. The history of that set out in Masry, but now it's all Section 37 of this Senior Courts Act, albeit that it's said, I think, that the same sort of considerations apply, and that's why Mr. Justice Marcus Smith is saying, presumably, if you could do this just by way of seeking an order for sale in the King's Bench Division.
And there were already orders for sale.
Oh, there may well be, but that's right. But what he's saying is, okay, so if you could achieve what you need to achieve by an order for sale in the King's Bench Division of the individual property by way of legal execution, charging order for sale, you don't need a receiver.
Yes.
Under Section 37, but it's because this is a more complicated set of assets that need to be sold together that you need to have a receiver.
Yes.
Or at least you need I think more technically, he probably was saying you need the option of being able to sell them together.
Yes, my lord, you may be strictly correct about that. May I just, if you'll forgive me, pick up on the phrase, it's all under Section 37. I'm probably misquoting you, forgive me. Whilst the jurisdiction to appoint is now Section 37, I may still need, if you're going to hear me on the duty ground, to get into the origin of receivers' quotes by way of to make good my point.
You're going to take us back to the Pre-Judicature Act of 1873, are you?
Not sure whether I go that far. But the point I'll seek to make is that the duties...
Since then, it's quite a difficult submission to make, isn't it? Sort of since the fusion of law and equity.
Well, you've seen our duty ground and how it's put in the skeleton. It may not matter, actually, given the shortcut that I've identified. So I'm not sure whether I will need to trouble you with that.
We'll see.
But we'll see where we get to, if that's all right. So that was Mr. Justice Marcus Smith's decision on the appointment of the receivers. As for the evidence that went before him on the 5th of June, or in connection with that 5th of June application, can I first of all take you in the supplemental bundle at tab 9, where you should have a second witness statement, Mr. Cooper's second witness statement, 22nd of May 2019. You have there reference to the receiver's view of value.
Sorry, I failed to get the paragraph number.
Forgive me, it's supplemental bundle tab 9, page 52, paragraph 30. And perhaps, forgive me, you're still reading.
That assumes that you're, quote, selling a football club.
Yes.
Hence, back to the point, you're selling the club rather than the assets.
Yes, you're selling a package of the footballing assets.
Yeah.
May I then take you back in that bundle to tab 5, which is the confidential exhibit to Mr. Cooper's first witness statement. And there's a relatively long passage here. It's paragraphs 6 through to 31, starting on page 27.
Do you need us to read the detail of that?
I don't think I do.
Just see the overlay.
Well, I don't think I do need you to read the detail. Can I take you to paragraph 31, which is the conclusion of that section, where Mr. Cooper says, as noted by the stadium valuation, it's not realistic to sell the stadium as separate assets, I think, because one, the values are based on assumptions that do not exist. Two, there's no market for the sale of the stadium without the ongoing operation of Blackpool FC. That's what I would describe as the playing club, rather than the club meaning the footballing assets. And then three, without the stadium income to support its income or with increased expenditure in the form of rent for the stadium, the playing club will have an estimated additional loss of £875,000 per year. My lady, my lord, Junior, Mr. Burton asked me to point out paragraph 6 and 7, which is quite right to do. And you'll be able to do that. Finally, on evidence, on this point, Mr. Cooper's third confidential witness statement is in tab 13 of the supplemental bundle at page 70. I've already shown you this, it's the last paragraph of it. I remain confident that Mr. Sadler's offer is the most positive offer for the receivership and the future of Blackpool FC, which is capable of being delivered in the required time frame. Molly, those are the references that I was going to find. As you can see, the detail of the bids is quite clearly set out there. Forgive me. Yes. That then takes me back to Mr. Justice Marcus Smith's judgment of the 5th of June. And we got in there as far as paragraph 41 before we came to the analogy that was drawn.
I'm sorry, I lost that. That is at...
Forgive me, it is supplemental bundle, tab 15,
Thank you.
and we were at page 91.
91. Mm-hmm.
And I've just shown you paragraph 41 and the requirement on these receivers to go back to court with
Yes.
respect to the sale. I was coming on to look at the analogy that was drawn and found to be apt in the words of Mr. Justice Marcus Smith at paragraph 43. My learned friend says this is an analogy to administrators. I say, in fact, it's an analogy to trustees. I say you can see that from the middle of paragraph 42. He being Mr. Phillips, sought to analogize those duties to the duties of trustees. And then at the end of that paragraph, he contended that the analogy sought to be drawn by Mr. Justice Snowden as between administrators and trustees ought also to extend to receivers by way of equitable execution. This may sound like a picky point, but the reason I'm raising it is because my learned friend in his skeleton says we must concentrate on administrators. And then he seeks to draw all sorts of parallels between administrators and the receivers in this case. And my point is that, well, that wasn't the analogy that Mr. Justice Marcus Smith was finding to be apt. And of course it wasn't, because we go right back to Public Trustee and Cooper. And therefore, the points that are made in the way that the learned friend suggests don't have anywhere near the force that he suggests they might have. I can go through them in detail briefly in a few moments.
But these creatures are not in little hermetically sealed boxes. As we
Right.
saw from MF Global, administrators can also be in control of a company which is a trustee company.
Indeed.
For example.
Yes.
I mean, I'm not sure. I'm not sure it actually helps to sort of try and segregate the analogies, if I can put it that way.
No, well, can I put it this way then, my lord? The analogy always goes back to the trustees. Or,
Well, that's where it all started.
yes. And then one has to look at how that applies in whichever context one is in. You might say, because I do note from the order giving permission for this appeal, that it's your intention to give guidance, that one has to look at the potential range of applicants who might seek this sort of relief as a group to give guidance.
I don't think there was any promise, by the way. I think it just said it might benefit from consideration
Well,
by. I don't think I was saying that.
Indeed. If the court were minded to give guidance, then it would be appropriate, in my respectful submission, to group together the various sorts of applicant who might seek relief under what I'm going to call the Public Trustee and Cooper jurisdiction. And that's one thing. I can address you on how that might work and any concerns as to floodgates and that sort of thing. On the facts of this case, where I go in my submissions is the receivers had to go out to court. I've shown you that. Mr. Justice Marcus Smith, as I'll show you, says, well, they were right to do so. He recites the bids and identifies the one they think is best. And he asks himself the classic questions under the Public Trustee and Cooper jurisdiction. And he says this is the sale that should go ahead, which it does. And within that or from that rather, flows the immunity that Mr. Justice Fancourt found. Because, as I sought to explain at the very beginning of my submissions, the claim that is now advanced, you should have sold differently, is not available in the light of the blessing, sanction, approval, doesn't matter, for this particular sale to Mr. Sadler. If I then zoom out, forgive me, horrible phrase, to general guidance, you might say, well, the problem here is that your facts don't apply generally, and that would be right because of that obligation to go back to the court under paragraph 18. Insofar as it helps, far be it from me to suggest how you might give guidance, but one might look at the detail of what is put before the court asked to bless the transaction. So here we have a lot of detail. I've shown you that Mr. Cooper's evidence, as opposed to we're just going to sell it in broad terms. There might need to be an express request in cases going forward to make it clear that what is sought is this immunity. And to address the floodgates point, these are just commercial transactions point. These sorts of transactions need to be momentous. That acts as a filter. That will be rapidly apparent if anybody tries to come along and have blessed or sanctioned or approved an ordinary commercial transaction, where the T&D industry's line of authority would say that's not appropriate. And if need be, in an appropriate case, which must be rare for reasons I'll explain, it would be possible to vitiate or set aside the blessing. So, for example, if something turns up that could not reasonably have been known about when the blessing was sought, because the court has a supervisory jurisdiction over its officers or over office holders, then the court could be asked to set aside the blessing. Now that must be rare.
If something new turns up, or alternatively, if it transpires that actually the evidence didn't give a whole picture.
Indeed. So there could be that, my lady.
I think that's what you mean, isn't it?
Yes.
When you say something new turns up, it's my lady's point that, I mean, if something subsequently happens that makes it look as if it wasn't quite such a good decision, I mean...
Well, that's different.
That's different. So
yes.
When you said something new turns up, I think what you mean is
something
that should have been disclosed.
Couldn't have been known, wasn't known about at the time, or ought to have been known about, or ought to have been raised. Yeah. I think that covers it compendiously. But one might say, well, that's unlikely, because, well, if done on notice, then it's very easy to stop sanction from being given if there is, quotes, any doubt that it ought to be given. I'm going to bring this back to the facts of this case in a moment. Because you'll recall that the court acts with caution because of the very consequence of giving blessing.
Well, it depends on the consequence. If you're told I want blanket immunity, the court might be very much more reluctant to give it. Yes. If it's told, I just want you to go through the public trustee and Cooper rationality questions, but nothing more.
Yes.
Then the court doesn't need to start concerning itself about effectively trying a professional negligence claim in advance, which is Mr. Collins' point.
Right.
So it will depend.
Yes, it would depend, yes.
And also, the greater the stakes, let's put it that way, the more important it is that the court also has the view of all those who might be affected. And I'm thinking, therefore, of what Mr. Collins said about Mr. Oyston's standing and his ability to, an opportunity, and I'm sure you'll say something about that, to put matters before the court. But in bigger, more complex matters even than this, whether there are beneficiaries or groups of creditors, etc., who need to be represented before the court, possibly.
Possibly, yes. That might be that might, on the fact of any particular case, be a consideration that needs to be addressed. But there is an evidential obligation on the applicant, that comes from Cotton and.
That's Brunel, Bruce.
Yes.
Yep.
But it depends what they're asking for.
Well, indeed, indeed, absolutely.
I mean, if you're not asking for immunity from professional negligence, you don't need to put in front of the court the same sort of material.
Yes.
If you're asking for a blessing that you're not acting in conflict with a conflict of interest, to
Yes, well,
take
quite.
one of the examples.
Right. But that's why I've been making the submission that it all depends on what you go along and ask for.
And does it depend upon how clear the judge is about what he's or she is doing?
Well, I suppose it might be said. Well, forgive me. That's the point about being upfront about what you're asking for.
Well, but at the end of the day, we're halfway through Mr. Justice Marcus Smith's judgment. We need to be clear about what.
Well, he was clear. I'll come to the fact of this case. He was clear.
I was really just trying to lead into the remainder of the judgment in a sense.
Indeed.
That must be part of the equation.
Yes.
And you said a little earlier, being clear about what you're asking for, but also what you're asking for in terms of immunity.
Yes.
So that there's no doubt about what the judge thinks he's doing.
Quite. My lady, if the court is minded to give guidance, that would be guidance for the future. I say there isn't a problem in that regard on this case, because Mr. Justice Marcus Smith was very clear about what was going on. And I've already shown you.
I think the point you need to deal with is that he wasn't so clear about the immunity.
Well, he wasn't. He decided not. He wasn't. He didn't grant any immunity. He said it logically flowed. You didn't need to deal with it.
He said he didn't need to deal with it, didn't he?
Yeah. I'll take you to that in a few moments. It's not very much further on in the judgment. So, forgive me. I said I was going to avoid looking at the transcript of the hearing for Mr. Justice Marcus Smith. I'm afraid I need to renege on that promise, very briefly, and look at page 110 of the supplemental bundle behind tab 16. Just supplemental tab 16, page 110. I'm going to look at the bottom right hand quadrant. It's marked as page 31. And these are the submissions of Mr. Phillips, King's Counsel. And he starts at line 6. This is the decision of Mr. Justice Snowden. That's a reference to Nortel.
Yeah.
My law's decision in Nortel. If you read to line 18 of that page, I'm then going to go over to the next part. And over the page, 111, bottom left quadrant. Line 3 is a question from the judge.
Well, you need to pick it up at line 20 on the previous page, I think.
Yes, well, my lord, by all means. That's a reference to the questions that arise in public trustee.
Well, he says, you know, I'm not concerned to second guess the receiver's decision.
Right.
Or else to ensure they're acting properly within their powers and they're taking a course that, viewed as it were from a certain distance, is one that is proper.
Yes.
So, I mean, if he's talking about Nortel again, we are talking about a case where, if we go to Nortel, we'll go to Nortel in a minute. It's clear that I, rightly or wrongly, didn't think I was conducting a duty of care type analysis of how the administrators had got to the global settlement, because that would have been just impossible.
Well,
And so I was doing it as it were, from a certain distance. In other words, I think Mr. Collins would say, what he has said, not covering duties of skill and care, but checking powers, conflicts. Have you missed anything out by way of necessary factors, if you like?
Yes.
Rationality.
Yes. But this case is different.
Yeah, no, but Mr. Justice Marcus Smith seems to be talking about himself. I am not concerned.
Yes.
So he's sort of, at least there, looking at it as if it was
indeed
on all fours with Nortel.
Well, I can see that comes out of that bit of the transcript. He then asked the question at line 3 on the next page.
Yeah. So
you then get the response, Mr. Justice Snowden's judgment will answer that question, but the other way, because in answering those questions, what Mr. Justice Snowden says is that the court acts with caution because the result of giving approval is that the beneficiaries will be enabled thereafter to complain that the exercise is a breach of trust and even set it aside as flawed. And then, my Lord, rise over at page 112. Bottom left quadrant again, having quoted from the judgment in Nortel, at line 3 on page 37, Mr. Phillips says, once questions have been answered, there's no room for there to be a challenge thereafter by a beneficiary, or in this particular case, Mr. Royston.
Just to be clear, I don't think, Mr. Phillips, I think this misquoted me, isn't it?
Forgive me.
Maybe he hasn't, I don't know, but I don't get.
May I turn up your judgment in Nortel? You can check the points.
Those words, I think, are actually.
They may be the words of the Justice David Richards.
I think they're from another judge, actually.
Another one.
Because.
Well, he is purporting to read from your judgment.
Anyway, as I said,
may I show you
the better question is, if that's what I said, would I have been right to say it? I do recognise those words, but not. I think those words.
It looks like paragraph 47 of Nortel.
No, I don't think it's 47. I'm going to say.
Well, I get that from line 5 on page 36. The innocent case is, in my judgment, such a case. I'm signing the document. And then I think it goes on through the quotation.
It's certainly true that what the reason what I'm picking up is what I was picking up is that the result is that beneficiaries will be unable thereafter to complain that the exercise is a breach of trust and even set it aside as flawed, which seems to be quite wide worded.
It comes from Lewin on trust, I think.
Yeah.
It's cited and set out in 48 of Nortel.
Yes. There we go. Thank you.
I'm very grateful to my lady Justice Falk for that. It's the top line of page 603 of the report in Nortel, 438 of your bundle.
But what you have to, surely what you need to do is to read the preceding sentences. Because what Lewin says is, once I'm reading just above H in Nortel, once it appears the proposed exercise is within the terms of the power, so that, I mean, that could be, as my Lady Justice Asplin said this morning, you could have trustees who just simply come to court and say, is this within our powers? The court is concerned with the limits of rationality and honesty. It doesn't withhold approval merely because it would not itself have exercised the power in the way proposed. In other words, that's postulating, even there, a more limited review,
Yes.
i.e. of the type in Nortel, namely rationality,
Yes.
taking in no conflicts, taking into account the correct factors, but not saying, I'm satisfied this has been arrived at with due skill and care.
Yes.
So I'm just and when you go on to read, when they'll be enabled thereafter to complain the exercise as a breach of trust or even to set aside as flawed. I mean, flawed can simply mean vitiated by conflicts or some lack of rationality. It doesn't necessarily mean that you're prevented from seeking to challenge whether the trustees arrived at the result with due skill and care, for example.
Indeed, I accept entirely it's possible to read it that way. But that then takes me back to it. Depends on the application.
Yep.
What I was hoping to do, forgive me, what I was hoping to do was identify what had been said to Mr. Justice Marcus Smith.
Sorry, I got distracted simply because
So as to show you what he was aware of when he came to give his judgment, which if I can take you back to in tab 16.
Tab 16 were in the transcript.
Oh, forgive me, 15, I do apologise. 15, page 91, paragraph 42. What Mr. Justice Marcus Smith does there and in the next paragraph is say that he considers the analogy to be an apt one. He then quotes from Nortel, which I think he's quoting a quotation, as it were, and then finishes his extract at paragraph 49 of my Lord Justice Snowden's judgment. We then get to paragraph 44 on page 93, which I think was the point where the syntax was picked. He says it's open to a receiver by way of equitable execution to come and ask for directions, and he then gets into the question whether this is a momentous decision, and he says it is. Then at 46, he recites submissions by my learned friend about immunity, and this is where he identifies that it's not a question that's before him on the 5th of June, but it follows from the analogy with Nortel, but it's unnecessary for him to decide that point today. And then he goes on to say this: it seems to me the more important point is that there are some transactions conducted by receivers by way of equitable execution that are of sufficient importance so as to require the court appointing such receivers to look at the transaction in question to ensure that it is in the interest of all concerned. If, as a result of such scrutiny and approval, a degree of immunity follows, then so be it, but I do not decide that question today. So I say it was clear to Mr. Justice Marcus Smith what the consequence might be of the scrutiny and approval which he was asked to give, he did give, to the sale proposed to Mr. Sadler. The passage that starts at paragraph 47 of the judgment is about the variation of the buyout order. I don't think I need to take you through any of that, because it's not relevant to this appeal. And then one can turn all the way through to paragraph 70, where he deals with his third and final question. It's page 102, forgive me. This paragraph repays some detailed consideration. And Mr. Justice Marcus Smith says this: I move on to the third and final question, namely whether I should approve the sale of the club. It would appear that Mr. Royston has no issue with the sale. He has certainly not raised such an issue. In his statement before me at paragraph 8, he seeks to reserve his rights to make further points. And that was the witness statement I showed you a little earlier. That I consider is inappropriate. Mr. Royston has had every opportunity to take points in relation to the proposed sale. The timetable leading up to this hearing was structured expressly with Mr. Royston's interest in mind. It is, in my judgment, inappropriate for Mr. Royston to say, as he does in paragraph 8, I've not commented on the evidence as to marketing, I think it should be and value, as to which my rights are reserved. It seems to me, however, that it is significant that at this hearing, Mr. Royston has raised no substantive point against the transaction that the receivers propose. And I've already shown you, in particular, the correspondence from Stevenson Harvard that made it clear to Mr. Oyston what it was that was being sought, and also the relevant passage in Skeleton Argument.
I mean, it's important, isn't it, just to put your finger in paragraph, page 102, but also then to turn back to page 85. And the paragraph my lady picked up, paragraph 17.
Yes.
Because that's where the judge defines what he refers to as the club.
Yes.
And makes the point that the evidence confirms a better price could be obtained by selling the club as a going concern rather than by selling the receivership assets separately in an asset sale. I mean, that's the express connection he makes.
Yes.
That's why I've asked the question right at the start about, what do you mean by club?
Yes.
But it's clear he means club as defined in paragraph 17, which means everything, because that's the best way of doing it. So you could you not, read this paragraph as his view that Mr. Royston has no issue with the sale being the sale of the club as the collective set of assets.
Well, I suppose you could, save that also, you've got to read the judgment as a whole, he goes on to, in paragraph 73, to deal with the details of the sale in question.
But even on that basis, you say, well, but that is in effect what the current points of claim seek to now criticise.
Yes.
So that's enough to get, you say that's enough to get you home.
Quite. That's why I started with the drafting many particulars of claim.
Okay.
It seems though in 71 and 72 the judge is looking at the classic public trustee and Cooper questions, but then in 73 descends to the detail of the precise transaction.
Yes. And that, my lady, would echo the obligation he identified by reference to paragraph 18 of the Receivership Order, or the spirit of paragraph 18 of the Receivership Order, that the sale had to come back before the court for scrutiny. Hence his reference elsewhere that I've taken you to scrutiny and approval.
I mean, the questions he asked himself in paragraph 72, at least on their face, don't expressly include the question of have they acted, have they marketed with all due skill and care, for example. He's talking about, is it a proper one?
Yeah.
Do they genuinely hold the view the transaction is a proper one which should be entered into? He doesn't want to second guess them. Is he actually really turning his mind to the detail? The pounds and pence, as it were.
Well, what I say he is, because he's been shown that detail in the evidence, and he's recited the bits, albeit in fairly summary form, earlier on in his judgment.
But what does he mean without seeking to second guess the receivers?
Well, I think what he's going...
What's the purpose of asking him to look at the pounds and pence if you're not asking him to second guess the receivers?
Well, Lord, what he's being asked to do is scrutinise and approve this particular sale. That's what he does. He does it knowing the detail of the bid that the receivers favour. I don't actually know what he meant by that. The best I can do is say, well, he might be meaning to refer to the fact that their discretion has not been surrendered, in that they are making the decision to sell.
Can I suggest at that point, in other words, if you go back to the extract from Lewin or all the other point cases, they make the point that the court might approve or sanction a sale. I don't, for the moment, let's not worry about whether it's approve or sanction. The court might give its blessing to a sale.
Yes.
If it's rational and one that a reasonable administrator could enter into that a rational administrator could enter into having considered all the relevant factors, even if it's not one that the court itself would have decided on.
Yes, well,
I mean, that's maybe, which again indicates that he's actually probably adopting a slightly higher level review of this transaction.
Well, I might be tempted to agree, but for the fact of the passage in his judgment that recites paragraph 18 of the Receivership order and the obligation to come back to court for scrutiny.
Yeah, and possibly the next paragraph where he seems then to go on to say
Indeed.
It's clearly, well, he talks about it reasonable and clearly the best bid, but
yes,
not necessarily the best price reasonably obtainable.
No, he doesn't say the best price reasonably obtainable. If I had to, I suppose I would say, well, that's implicit in what he's saying. But actually, what one gets to is the danger of scrutinising in detail after the event the words of a first instance judge that might be scrutinised on appeal. If I might pick up on a point my Lord made earlier about your own judgments at first instance. So it's difficult, in my very respectful submission, to read too much into exactly the words used and try and identify what it is he meant by second guessing, when I can see, or you can see, you'll forgive me, from paragraph 73 and the earlier passage about part 18 of the Receivership, that there was a need to scrutinise in this case. And I accept that won't be in every case. I accept that.
If the judge, if Justice Marcus Smith had not parked the question of immunity for another day, but had actually thought that was something that was relevant to the decision that he was making, would he perhaps have been inclined to, as it were, think about this, the exact way in which he was validating the transaction or approving it differently? I mean, I'm thinking now, both specifically and generally.
Yes.
I mean, if you think about what the my Lady Justice Falk put to you, it's if you think about the consequences in terms of immunity and spell it out, it might become clearer to you what, as a judge, you're actually doing and how much you actually have to look at. They're two sides of the same coin.
Indeed. I can see the point. As a matter of generality, giving guidance for the future, I can see that that might be the best thing to do. On the facts of this case, I say Mr. Justice Marcus Smith was in no doubt about what he was being asked to do. And because he expressly considers the question of immunity, he knows full well, because he says it would logically follow, that that might be something that comes back. But he rightly, in my submission, says he doesn't have to deal with it on the 5th of June. Because at that stage, there is no challenge, used broadly, to the sale for which his approval is sought.
Well, what he says at paragraph 70, without wishing to repeat it, is he says there's no challenge to, certainly on one view, there's no challenge to the aspect of sale of the club, capital C, which you say is now the sole content of the claim sought to be brought.
Yes. And you have to bear in mind that there's the letter from Stevenson Harwood in all this, which makes it obvious.
Well, indeed, you've said that the whole basis of the receivership application was to sell assets together.
Yes. Yes, I do. And I identify that from the judgment given on the appointment application. Can I also draw your attention on this point to paragraph 71? And this does look at least at first sight, simply like a reference to the public trustee of Cooper. But I draw your attention to the words scope of the powers conferred on them by my order, and go back to the submission I've made a number of times now, forgive me, about the need to come back to the court for approval, because the powers conferred on the receivers by the appointment order, whilst there was a power to sell, included also paragraph 18. So, my ladies, my lord, you end up with the facts of this case, which are very particular. And then a more general approach, if you're minded to give guidance. And you would have to strip out from that the particular facts of this case, especially the obligation to go back and ask for scrutiny and approval of the sale proposed. Because that's not going to be present in, if there is such a thing in this area, an ordinary case.
But in this case, you have paragraph 17, where he says there's no evidence before me that one could get a better price if one broke it up.
Yes.
And then 73, where he says competitive process, price a reasonable one, and best bid.
Yeah. I may be straying into the abuse ground, the used to be called Henderson and Henderson abuse ground, with this submission. Forgive me. It would have been the easiest thing in the world for Mr. Royston to say, these receivers can get more money if they sell the assets separately. It's accepted, and this is recorded in Mr. Justice Fancourt's decision, that both the claimant and Mr. Royston had access to the collier's valuation, upon which that assertion would have been based. And because the court acts with caution, and this is also Mr. Justice Fancourt's judgment, had that point been made, there is every probability in my submission that Mr. Justice Marcus Smith would have stopped and would at the very least have required the receivers to furnish him with more evidence.
So when you say that that submission would have been based upon the Collingwood...
Colliers.
Is that...
Yes.
Can you give me the reference? I'm afraid that's...
It's not in the bundle. Neither of the valuation reports are in the bundle. The receivers was Lambert Smith Hampton.
What I'm getting is why do you say that?
Because the Collier's valuation is the one relied upon by my learned friend in the particular claim.
Is that the one that that gets to the 25 million?
Indeed, yes.
It's referred to in some of the evidence that
Yes.
has been before
Yes.
the judge.
Right.
Yeah, that's entirely it.
Yes.
And it was available to Mr. Royston and to the claimant, to the appellant. And it would have been, in my submission, the easiest thing in the world in Mr. Royston's witness statement at paragraph 8, rather than to have said, I'm reserving my position, to have said, well, hang on, you can get more if you conduct an asset sale.
So when was that? We haven't got a copy of it, but is it referred to in one of the judgments somewhere? And
It's referred to in Mr. Justice Fancourt.
and where? Can you just give me the reference then
Yes,
to that?
give me a moment, I'll tell you.
When it was provided.
When it was
If there's
provided.
a summary of what it says and when it was provided.
Yes. Give me a moment, I'll turn it up for you.
There's Collier's International referred at paragraph 28.
2018.
Forgive me, I'm sorry. Could I?
Paragraph 28 of Mr. Justice Fancourt's decision says it's accepted by
Yes.
Denaxe that Mr. Oyston knew of and had access to evaluation of property assets of Denaxe prepared by Collier's International on the 15th of September 2018. This was a red book valuation, etc.
My lady, I'm very grateful. That's entirely it.
So the point being, your point being that Mr. Royston could have said to Mr. Justice Marcus Smith, if he was, as it were, notionally sitting there when he's writing paragraph 70, or paragraph 17 in fact, wait a minute, there's a valuation that suggests you'll get more than this by selling separately.
Yes, well, Mr. Royston went to the length of putting in a witness statement, which I've shown you, which is the I reserve my position witness statement.
Yeah.
Which is criticised by Mr. Justice Marcus Smith in paragraph 70 of the 5th of June judgment. That witness statement was the ideal place to say, as my lord has put it, hang on, you can get more if you do this differently.
Specifically, more if you sell the assets separately.
Yeah. If you look at page 9 of the core bundle, you should have paragraph 46 of Mr. Justice Fancourt's judgment. And it's 46 Roman 1. Ladies, my lord, it's pointed out, and I'm helpfully reminded, that there is detail about this in Mr. Cooper's witness statement, second witness statement, on the strikeout application, which was before Mr. Justice Fancourt, were you to want to see what's said about the different valuations. But I'm not sure it's necessary to take you there now on this point.
For myself, I don't think we need to go there now.
No, grateful. Unless I can help any further on those points, the conclusion that I invite you to reach is that Mr. Justice Marcus Smith knew full well what was being sought here, and he gave the judgment in the terms he did. And the consequence of that is that Mr. Justice Fancourt was entirely correct when he found that the receivers have immunity from the claim that is now put sought to be put against them. And whilst I can, though, if it's convenient to you, if you'd like to hear from me on it, I can go to the duty ground, why I say there is only an equitable duty owed by the receivers, such that there's no common law claim anyway. The source of the duty, the nature of the duty doesn't matter on my, hasn't turned out to be quite as short as I thought, shortcut by looking at what it was that was asked for in order to inform the question, what immunity has come out of the other end of the process.
You just give us a moment.
Yes.
Yeah. Yeah. We don't want to detain you too long on that. If you could just give us some headline, thumbnail sketch only of
Yes.
that issue.
It's in the skeleton.
Yep.
The headline points are these. These receivers, appointed pursuant to an equitable jurisdiction, owe equitable duties. I take my Lord's point about Section 37. The origin of their duties is equity, they owe equitable duties, just like other receivers. That's in our skeleton. And we point there to the cases, the decision in Downsview and of Armed, and as far as I need to have Silver and RBS. Because they already owe equitable duties, there is no lacuna that needs to be filled by the imposition of a common law duty. When, as I think he does, my learned friend accepts immunity in respect of an equitable duties claim, even if he is right on his narrow interpretation of immunity, because the only duties the receivers owe are equitable ones, they have immunity in respect of them. That then takes me to, sorry, that was very quick. Is that sufficient?
I understand the proposition that when deciding what duties are owed by court-appointed receivers, you might have regard to the principles set out in the equity cases,
Yes.
which was the foundation for the jurisdiction.
Yes.
What I am not clear about is why, since it has become a statutory jurisdiction, that the duties are equitable only.
Well, in that regard, I'd simply say that other court-appointed receivers owe equitable duties, not common law.
So other court-appointed, so I don't understand. And there's only one species of court-appointed receivers.
Sorry. Yes, all right. Let me put it this way. Court-appointed receivers owe only equitable duties.
What's the authority for that proposition?
So that's in our skeleton. No, I'm sorry, I'm mistaken. Just give me a moment. So, Lord, forgive me, I put the point too broadly. Can I take you to paragraph 44 of the skeleton, my skeleton?
Yep.
First, we take the point about the origin, which I think my Lord already has.
Yep.
We then say by reference to mirror group that court-appointed receivers act as fiduciaries.
So do office holders who have common law duties.
That's entirely right. Well, forgive me. Claims against court-appointed receivers are generally put on an equitable basis rather than a common law basis. And we say that's, in this case, because the duties that these receivers owe are equitable, and therefore there is no gap to fill, as there was in Hoogstraat.
Well, it's quite clear that a court-appointed receiver is a fiduciary and therefore will owe duties that are enforceable in equity.
Yes.
I've no difficulty with that proposition. A court-appointed receiver, though, also is in charge of property belonging to somebody else that he has a duty to deal with.
Yes.
And he owes a duty to exercise skill and care in doing it.
And we would say that's an equitable duty.
Why? Given that he's appointed by statute, under statute.
Well, he's now appointed under statute.
Yeah, well, this receiver always was.
Yes. But one looks back to the origin of the power to see what sort of duty those receivers ought to owe.
But the origin was at a time when it was only equity that had the jurisdiction to appoint the receiver. That's the origin. That was the whole point. Equity appointed the receiver because you couldn't get good execution of law. But we're long past that. This is a statutory jurisdiction, which is very broad.
And it is. But my point is, there is no reason to depart from the proposition that the duty is equitable simply because there's an appointment under a statutory jurisdiction. And rather, because that duty existing, there is no need for a common law duty. There's no space for it.
Right.
So Hoogstraten was a case where it was perceived that there was a lacuna, and therefore on what was then the favourable Anson Merton or Aronson and Aronson test, there was room to impose a common law duty, because otherwise there was a gap. There's no such gap here. Yeah. And to flip the question the other way, where is the origin of the common law duty that is said to arise and said to be owed by these receivers? We can identify the origin of the equitable duty, but it's very difficult to identify the origin of the common law duty that's contended for. And our point is, there is obviously a route to saying there is an equitable duty, therefore no need for a common law duty, and the Privy Council in Downs' view warned against imposing a common law duty where there was already a sufficient other here equitable duty, for the reasons set out on page 316 of the report.
Downs' view was complicated by the fact that you've got different players involved, mortgagees.
Yes.
Okay, all right.
But in my submission, that proposition
I think,
wasn't good.
okay, we've probably indulged my anorak tendencies long enough, so perhaps we ought to move on.
It's in your skeleton. Thank you.
Yes, I'm grateful. I've already made the point that the analogy is not to administrators, and therefore my learned friend's point of concentrating on administrators is a bad one. I don't think I need to develop that any further. I do need to deal with the Montin cases. What I say about these very shortly is this. Montin osmosis say, well, there are administrator cases. The administrators want to sell before a creditors meeting has taken place. When Montin and osmosis came before the court, it was on the basis that the administrators could not do so without a direction from the judge, allowing it to happen. Hence the request for, as it were, permission, or better put, then leave to sell prior to a creditors meeting. That changed in T&D when it was said that was a misinterpretation of the statutory provisions then in force, and in fact that permission was not needed. There is no help to you for the reasons I've set out by reference to paragraph 18 of the Receivership order and the obligation on these receivers to come back to court. And my ladies, my lord, a point is taken by my learned friend about the referencing to Hoogstraat, and I should have dealt with this a few moments ago, I'm sorry, on the discharge application and in the hearing of the question whether permission was needed for the claim, which my Lord Justice Snowden heard at first instance. The short point is that the question of duty was never examined on either of those occasions. And so nothing that was said then has any bearing on how Hoogstraat works now, and I've already explained how I see it. There are a number of authorities in your bundle showing you how this jurisdiction has been applied in the insolvency context. I don't know whether it's useful to you for me to take you through them. You've seen MF Global and Nortel. We've put the others in so that you had them in the event you want to give guidance in this regard. But I'm not sure that anything can be gained now from me taking you through them.
Not for me, certainly. No, thank you.
Grateful. Can I then ask a rhetorical question, which is this, forgive me. If the immunity were not as we contend it to be, what would the point have been in making the application in the detail I have shown you to Mr. Justice Marcus Smith? It's the question my Lady Justice Asplin asked a learned friend about purpose. And we say this is one of the unattractive elements of the appellant's case, that it invites the conclusion that there was no point in coming before Mr. Justice Marcus Smith in the way that these receivers did, because they hadn't obtained the immunity that flows, we say, from the approval of the sale. I can see my Lord frowning at me.
Well, so I'm just trying to follow this. You said they had to come back anyway.
Yes.
Paragraph 18.
Yes.
They wanted to ensure, let us say, the bare minimum, that it was okay to sell the club as a going concern whole,
Yes.
i.e. everything together, because that's what the purchaser wanted. That required, as an auxiliary question, variation to the buyout order, but that's a related matter. Isn't that enough?
It is on the facts of this case, yes.
Yeah, I mean, put your question in a slightly different way, in a non-rhetorical way. If the purpose of your clients in going to court was to get immunity, where did they ask for it?
I accept in terms they didn't. I'm constrained to accept that by the transcript and the judgment and the evidence. I can see that entirely. But I've also shown you that there was no doubt about that, in fact, by reference to the Stevenson-Harwood letter, the submissions that were made, and the record in the judgment of what Mr. Justice Marcus Smith understood was going on before. And that's why I said, as a matter of general guidance, it might be best in the future, if you are to give guidance, to indicate that's something that should be said in terms. But on the facts of this case, there is no problem for the reasons I've already outlined earlier on today.
Yeah, I mean, there's been a lot of talk about, quote, momentous decisions as being some sort of gateway. I mean, that's just a word used in obviously a very important judgment, but it's nevertheless just a word. In a sense, the point I think Mr. Collins makes at one point in his skeleton, I mean, the fact that it's a bigger decision doesn't necessarily mean it's a reason to grant immunity. You could have a very big decision which is purely commercial, which actually the court could on one view just say, well, I'm not a commercial professional, you are, you've got insurance policies.
Well,
On the
yeah.
other hand, you could have a momentous decision in a very different family context with very little value attached, where frankly the immunity from suit is of much lesser importance than resolving the family conflict on a trust. You know, I mean, the point is, I think what you're saying is it would be as well if people who apply to court wanting as either their main or at least a byproduct of their application to have a degree of immunity from suit ought to say so. Then everybody knows where they stand.
I can see that for the future law.
Yeah. And it would, yeah.
But it certainly can't be said by my learned friend that they didn't know because they referred to the possibility themselves in their skeleton armour.
Yeah.
I've got very few points to make on the abuse ground. Again, Mr. Justice Fancourt was correct. He's an experienced High Court judge making a decision that these proceedings, for reasons unconnected with the immunity point, were the clearest possible abuse. That was his phrase that he used in the judgment. He was right to do so. Denaxe, the claimant, the appellant, was on notice of the applications. That now is beyond doubt, and supported them passively. It is very difficult for it now to say, I'd like to complain about what went on. The shoehorning point, as a learned friend has it, is met by the analysis that I conducted, I think before lunch, about looking at what was sought to be approved and what now is complained about. And the complaint that is made against me, that the claim now advanced could not have been brought before Mr. Justice Marcus Smith, misses the point. And you can see from paragraph 103 of Mr. Justice Fancourt's judgment, which is on page 19 of tab 1 of the core bundle, that what could and should have been raised is the same argument on which Denaxe now founds its claim, namely that the stadium and training ground, if sold separately, would have realised substantially more than £8.2 million.
Sorry, which paragraph?
That's paragraph 103
Thank you.
on page 19 of tab 1 of the core bundle.
But if you're right on the immunity argument, you don't need those.
Yes, quite. It's an alternative argument.
Why is it an abusive process to bring a claim from which no immunity has been conferred?
That's my friend's point.
Yeah, I know it is. So I'm putting it to you.
Yes, quite. If it was open to the claimant, not Mr. Royston, the claimant, to raise this point and stop itself from suffering the loss it says it has suffered by in reality the sale not being approved and therefore not going ahead, then it is an abuse to stay silent about it and later on, having let that sale take place, to criticise it for breach of duty and seek a very substantial sum in damages.
Doesn't that depend upon what the judge was approving, in inverted commas?
Well, insofar as it does, Denaxe knew exactly what was being approved.
Yes, but okay. Suppose if, for example, one of the complaints about this sale is that an advertisement wasn't included in the Daily Telegraph as opposed to the Racing Post, and Mr. Justice Marcus Smith wasn't looking at the detail of the marketing procedure because that's just, he was told there was one, but he didn't have expert evidence about whether that would have been what any competent receiver would have done. The immunity wouldn't extend to a negligence claim brought on that basis, would it?
Well, I think that depends on whether you view that as part and parcel of the transaction being approved, which we say it would be. And if the answer to the, put it this way, if the aggrieved party could have stopped the transaction from going ahead in reality by saying, had you advertised in the Daily Telegraph, you would have got more bids and therefore more money, then it behoves that aggrieved party to say so when it is on notice of the application for approval and not to hold it back and bring it later on in separate proceedings.
Does that mean that every single application that seeks approval for a specific sale has to turn into a preemptive professional indemnity negligence type?
No, that's the floodgates problem. No, because the court acts with considerable caution in this area. And therefore, if at a high level a challenge like that is raised, that ought to be sufficient to prevent the approval being given, which on the general case, not this case, the general case, would mean that the blessing that is sought is unlikely to be given, leaving the applicant, office holder or whoever, at risk if they go ahead with the sale. The practical consequence being the sale will not take place. And therefore, it doesn't have to become a preemptive strikeout of a professional negligence claim not yet intimated problem. Because operating at that higher level is sufficient to stop the approval and therefore, in the practical sense, stop the sale.
The onus being on the trustee or the officer of the court or the office holder to satisfy the court to the appropriate standard.
Yes.
And once that query is put in the mix,
Yes.
then unless they're able to do so, then the blessing will not be given.
Well, is there also another alternative that on some facts a blessing might be given, but explicitly less extensive than might otherwise have been the case because the judge is on notice of a particular point, not able to decide it, and basically says that on that point you go ahead at your risk.
Yes, well, that's of course possible, my lady, yes. And of course, what I'm contemplating is an on notice.
In a sense, that goes back to, well, yes, there are all sorts of extra problems with applications where you have disparate groups of creditors, beneficiaries, whatever, who just can't be before the court. We're talking here about a specific. But the point my lady's just made, if the judge is alert to the point, the order for approval can be tailored to insulate the holder of office from certain types of claim, but leave open others which can be brought.
Yes, that's entirely conceivable.
So it all comes back to the scope of the immunity.
Okay. Yes, I can see that point.
In the ideal world, put it slightly different way, in the ideal world there would be no gap between immunity and abuse.
Yes. Yes, absolutely. I agree with that. On the facts of this case, Mr. Royston had everything he needed to stop the approval being given. And he chose, in the words of Mr. Justice Fancourt, he carefully picked his battles. No challenge to that conclusion. He chose not to deploy this one-line point that could have been made in his witness statement.
Which one-line point?
If you, I have the collier's valuation. It tells.
Oh, okay. We're back to the sale.
Yes.
Sorry, we're back to the sale
Yes.
together
Right.
or apart.
Yes.
Okay, go.
Sell it apart, you'll get more money. That's all he needed to say.
Right.
But he chose not to. And now to try to cause, as its sole director, the claimant to run this claim, making the same complaint, is, as Mr. Justice Fancourt held it to be, the clearest possible abuse.
Is there any question that arises from the fact that at the time of the application, Mr. Oyston was out with Denaxe?
The only point that arises on that, my lady, I think is this. The correct avenue for the claimant is then, if it is aggrieved by what its then directors did, is to sue them for breach of duty.
But actually, that in the real world, on the facts of this case, Mr. Oyston was in fact before the court.
Yes, he was.
Had the opportunity to make the point, whether he was a director or not at the time.
So, my lady, yes. Not only is he named on both the application notices, so there's the variation and the sanction applications. Even if technically he doesn't have standing to be heard, Mr. Justice Marcus Smith tailors a process to make sure he can be heard, and here's from it. My learned friend attended on behalf of Mr. Oyston. It's deeply unattractive in my submission for the claimant to have done what it did and come along and say it can now run this claim. May I just turn my back for one moment? Very great. I'm very grateful, thank you. The only point that I wish to make is if you are going to consider giving guidance, it might be helpful to know whether a receiver, like these receivers, do owe a tortious or an equitable duty of care. Because as far as we're aware, there is no specific guidance on that point. It may be something, my ladies, my lord, you don't feel able to do. But were you going there, all I say is it would be tremendously helpful.
I won't say anything.
Of course. Can I assist you with anything else?
We're just wondering whether you've covered what you call your merits ground in your skeleton. Whether you need to.
Well, I don't think I need to at this stage, because I say it only arises if you're with my learned friend. Because if you're with my learned friend, then I say the court should make a conditional order dismissing my summary judgment application. So it's not something I need to trouble with in particular now. It's in the skeleton arguments. We say the fact that security has already been given doesn't prevent more security being given. In a sense, we have had the first CCMC because there was a hearing in front of, or resolved outside court in the Manchester County Court.
Why couldn't all that be dealt with by, if we were in Mr. Collins' favour, that could be dealt with by the judge with conduct, who's got conduct of the case?
Indeed, or it could be remitted to Mr. Justice Fancourt.
Oh, okay, whoever it is who's got conduct of the case going forward.
Who heard the merits
application.
application. Yes. Yes.
So you're content with that?
Yes, I was obliged to raise it because I think strictly it's cross-spirit. But if you're with me and you dismiss the appeal, then it goes.
Thank you very much
Very
indeed.
grateful.
Mr. Collins.
May I just dispatch the last few points made by my learned friend? It's obviously not appropriate to raise the issue of security for costs on a cross appeal from a Part 24 judgment. That's a matter for the court below where substantial security has already been given. It's not going to, in relation to your my learned friend's invitation to your ladyships and lordship to give general guidance. It's not going to be very difficult to give some guidance as to the fact that these receivers owe tortious duties of care, because they plainly do. My learned friend is driven in his skeleton argument to the unattractive proposition at any time to say that Lord Justice Dillon is wrong. IRC and Hoogstraten plainly provides for a common law duty of care, by which I mean a tortious duty in relation to sequestrators. He, in the same breath, deals with receivers. There's the clearest possible analogy, and the only thing that my learned friend goes to, which is Down's view, it is in a completely different context. And Sylvan, which is in the bundle, as well as Gomber in the Court of Appeal, make it quite clear, and indeed in Medforth and Blake, which is referred to in Sylvan, make it quite clear that the reason that there are only equitable duties where a mortgagee appoints a receiver is because a mortgagee owes equitable duties, and a receiver can only can't do any better than the appointor. As for abuse of process, my learned friend introduces a new terror to Henderson and Henderson, which is that if you're put on notice that somebody's going to breach their duty of care to you, it's really up to you to go and stop them, because otherwise you can then come back and say, well, you haven't stopped me, it's an abuse of process now to complain about it. That's not how things work at all. And lastly, in relation to my learned friend brushing aside
I think you put it slightly differently. I mean, the point is, it's not just you have to go along and do it. You were there.
Well, but I'm going to come on to there to do what?
Right.
Just
Okay, well, that may be a different question, but it's not really a question of, the terror that somebody has to suddenly go along to court to stop a breach of a duty of care. It's if they're already there looking at the transaction in question.
Absolutely. If they're asking for immunity from that,
right, okay.
Then you should engage with it. Yeah. And if they're either asking or it's even appropriate to ask, then you should engage. Neither of those, of course, is the case. I'll come on to that in just a second. Lastly, he sought to brush aside the insolvency authorities, Montin, osmosis, and so on. The problem with that is that T&D, this isn't about the sanction aspect of an old point under the Insolvency Act before Section 23 meetings of creditors in administration. It's the fact that the courts in each case went on to say, we'll deal with the PowerPoint, but we're not dealing with the merits. And that was clearly in T&D, and T&D is referred to in the relevant authorities, including Nortel. And the ringing words that come out of T&D, Mr. Justice Neuberger says the court is not there to act as a sort of bomb shelter for administrators. Now, getting on to the main point, the learned friend said early on in his submission that by the time of the hearing before Mr. Justice Marcus Smith, it was blindingly obvious what was being asked for, which rather suggests that it wasn't blindingly obvious from the outset. And let us pick up a couple of points that were made by my learned friend on the materials in the supplemental bundle, if I may. The first is at tab 12, page 61, the receiver's skeleton argument that was before the court on that occasion. We were, I think, taken to page 62 of the bundle in paragraph 2 of the skeleton, which provides as follows. This skeleton argument is filed on behalf of the applicants, the receivers, in support of their application for a direction that they may sell together as part of one transaction. 1 to 8, together the football assets. 9, the shares of VBFA, together with the football assets, the sale assets. So what they were seeking to do was, on the one hand, take what the receivers already had power in relation to, and on the other hand, what they didn't, VBFA, which was critical because you couldn't get a sale of one without the other, because nobody wanted Mr. Royston as a minority shareholder when the buyout order from the 994 trial was fully effected. He'd paid a lot of money by this point, but not all of it. And paragraph 30 of that skeleton argument on page 69, accordingly, the court is respectfully requested to direct the receivers to complete a sale of the, and then the definition is used of the sale assets. which means, on the one hand, the football assets, and on the other hand, VBFA shares, the sale assets. And that's what they were asking for. And then, of course, it goes on to Mr. Sadler on the terms outlined in Cooper 2. But you have to identify the thing. I mean, in Nortel, I dare say, my Lord Justice Snowden had vast agreements identifying what was sought to be done, but it didn't go into them because that's not what was being done. And let me make that good by going into the transcript in a little bit more detail than the learned friend did of the hearing before his lordship. I also point out that there was no suggestion in that skeleton argument that the receivership assets, with or without VBFA's assets, were to be sold together as a going concern. And our complaint about this is not the sale of all these assets together, it's the sale of all these assets together for the price which was realised. If they'd sold them all together for a proper price, I wouldn't have a claim because I wouldn't have suffered loss.
Well,
that's actually what the claim is.
The concept of as a going concern is just a label which you put on the fact that you are selling together the assets which you need to be able to carry on the football club, i.e. to kick the ball around on a Saturday and have people come and watch it, as opposed to stopping all that and inviting bids for the stadium, which could be from developers who just want to knock it down and build something else, or et cetera, et cetera,
Well,
et cetera. So, I mean, there's no magic in the use of the
there is a
expression
bit.
going concern, is there?
Yes, because they could have sold all the assets together to developers altogether, and the developers could have thought, great, I'm going to get the football stadium, I'll knock that down, I'll get the training ground at Lytham St Anne's, I'll put a load of houses on that, there's a car park, I can do something with that, there's a hotel, I'll either knock it down or see if I can deal with it, and if they'd sold it all together for a proper price, I wouldn't have a complaint. But the fact that they sold it as a going concern football club is the problem, because the football club was losing tens of thousands a month, and it dragged down the value of everything else. That's the real problem here. And it doesn't say we want to sell everything as a going concern. We want to sell it all together. In fact, the whole thrust of all of this was we want to sell our assets and VBFA's asset together. That was the real point of it all. And that's what my claim's about. You can't.
So Mr. Royston would have been entirely happy to see Blackpool Football Club bite the dust.
Well, regrettably, that's what we're talking about here. Is we're talking about a receiver's duty.
But that's the consequence of your submission, that Mr. Royston would have preferred that Blackpool Football Club would have been put an end to, and these assets would have been sold without the weight of the football club dragging them down.
Denaxe
is that really your submission? Denaxe
was entitled to have its assets sold for the best price reasonably obtainable, and that is my point. And they weren't, and they were not. I'm not subject to some estoppel about football in Blackpool. By this point, nobody wanted Mr. Royston involved.
No, but it's the reality of your submission about selling as a going concern.
No, because you could have sold the club to somebody else and it could have gone and played somewhere else. If they'd have got the club could be sold quite separately to somebody who was keen about all of this sort of stuff without necessarily its trading ground or something else. It doesn't mean to say that football in the Blackpool Football Club has to go. When Wimbledon moved from Wimbledon to Milton Keynes, it didn't stop being Wimbledon. It just went to a different place, which was a bit cheaper. Anyway, what we're talking about is the professional negligence claim, of which I have, which is properly arguable. Now, when we look at what the judge was being asked to do, the transcript is illuminating, and more illuminating than the references that my learned friend made. If we go to tab 16, at page 110, my learned friend started on page 31 of the transcript in the bottom right-hand corner, which is where counsel for the receivers was referring to Nortel. If you go to page 32 on page 111, line 8, it's absolutely right that the court does not want to get involved with the day-to-day commercial type decisions that administrators may have to make when you're dealing with something as particularly momentous. The court, then the case goes on to 14. The court should be concerned to ensure. Sorry?
I was wondering whether you could read all of it.
Sorry?
I was wondering whether you could read the whole extract.
All right. It's absolutely right that the court does not want to get involved with the day-to-day commercial type decisions that administrators may have to make. But when you're dealing with something that's particularly momentous, a very important step in the management of an administration of trust, or in this case a receivership, the court will get involved. Then Nortel goes on to say the court should be concerned to ensure that the proposed exercise is within the administrator's powers, reads to the words. The court, however, should not withhold its approval merely because it wouldn't have exercised the power proposed. Judge. So in short, I'm not concerned to second guess the receiver's decision. My role is to ensure that they're acting properly, both in the sense of within their powers and that they're taking a course one that viewed, as it were, from a certain distance is proper. Absolutely, my lord, yes. So does that answer one of the other points Mr. Collins made, namely we're in no sense here seeking to absolve the receivers from any claims that might exist by a third party against them? Mr. Justice Snowden's judgment will answer that question, but the other way, because by answering those questions, I'll show in a minute, what Mr. Justice Snowden says is the court acts with caution because the result of giving approval is that the beneficiaries will now enable thereafter to complain that and there's the use of the word complain, but it's that the exercise is a breach of trust and even set it aside as flawed. Absolutely classic public trustee in Cooper. And then he goes to MF Global at the bottom of the page, line 23. And we've already seen that MF Global is an application of public trustee in Cooper in the trustee context because it's a hybrid case. And so his lordship deals with that, the submissions are there set out in page 34. Public trustee in Cooper, and we go to the second category. Page 35, line 12, as that is described as a momentous decision which falls within the sort of circumstances where Chancery Division become involved in approving the exercise of a power. We have got here the sale of the football assets. Then, over the page, there is a reference at the bottom of page 36 to the word complain, and as my lady, Lady Justice Falk, pointed out, that comes from Lewin. It does actually come in your lordship's judgment in Nortel, yeah. But in the Lewin context.
In the Lewin quote.
Absolutely. And then you see, read on, set it aside as flawed. There's all the difference in the world between setting aside a transaction and complaining that it's negligent. The reason for that, my lord, this is at page 37, lines 3 to 7. The reason for that, my lord, is that when one looks at those questions, which we'll come to, there is no room when those questions have been answered for there to be a challenge thereafter by a beneficiary, or in this case, Mr. Royston. A challenge. And what challenge means, and we'll come on to how it's been distorted in the present situation. What challenge means is a challenge to the decision, to the transaction. It's not a complaint about it, it's an actual challenge to it. It's trying to impeach it in some way. And then that's repeated again, line 30, page 38, line 14. The effect of this is it will prevent a subsequent challenge. And then one goes through the various questions through pages 38 and 39, all straightforward Lewin, straightforward public trustee in Cooper, within the power, rational, have they in fact formed that view? Page 40, your lordship will note that you act with caution and note that the result of giving approval is that no interested party will be able thereafter to complain that the exercise is a breach of the receiver's fiduciary duties or even to set it aside as flawed.
So I think this is a contrast you raised in your opening submissions. You say what this is really dealing with is that after after approval, blessing, whatever you call it, the transaction itself can't be set aside by some third party on the basis that it was a breach of fiduciary duty by the directors, or that they acted in some way in a sort of circumstance that equity will
outside the power
intervene, excessive power, so that the actual transaction is unwound to the detriment, for example, of third parties.
Yes.
You say that isn't the case. That's not got nothing to do with whether it was just because a bad bargain because the receivers, for example, had been negligent.
Quite. And that's
because that's not normally a ground for setting aside a transaction.
Certainly not. No, because for all one knows,
Otherwise the commercial
Mr.
world
Sadler
would come to a
might
halt,
have got
so-
an absolute bargain
Yeah.
with all of this. But what we can't do is upset Mr. Sadler's bargain. Good for him. He's been very fortunate. But I can take issue, now that I'm back in charge of Denaxe, of the people who've given that enormous benefit to Mr. Sadler on the basis of having been professionally negligent in doing so. And my learned friend says, well, what's the point in the application which we made? Well, that's really a matter for him. But actually what the point was first, the point that they actually said, which was that they need to sell their assets and VBFA's assets together in one transaction, the sale assets as defined in the skeleton argument. And secondly, to provide certainty to Mr. Sadler in circumstances where I dare say it's all got a bit emotional and so on, and a bit of certainty in relation to all of this was possibly something which Mr. Sadler required. Now, so that's the transcript. We then go to the judgment, and which is just in the previous tab. Oh, and in fact, I'm sorry, page 113. I should have finished on this. I was looking at page 113, page 40 of the transcript. If you look at page 41 of the transcript in the bottom left-hand side, or just above it at the bottom of page 40, Mr. Collins' third point was that Mr. Oyston's evidence didn't address the substance of the proposal. The answer to that is that if Mr. Oyston had anything to say about the substance of the proposal, then he should have said it. There is frankly nothing that could have been said, because the receiver's conduct and the proposed transaction clearly fall within the test set out in Nortel. What the Receiver's Counsel is there saying is, no, don't start complaining about price and this and that and the other, because that's not what you do in Nortel. Nortel is at the higher level. And so there wasn't any point in me saying anything, not that I did, because I wasn't meant to, and that's exactly right. Now, if we look at the judgment, the first point that's made is this paragraph 18 of the order point, which is at paragraph 39 of the judgment, page tab 15, page 90 of the bundle. Now, the fact that in the receivership order, the judge specifically provided that if Mr. Oyston's shares in Denaxe were to be sold, it should go back to the court, rather suggests not that you should go back to the court for everything, but that you don't need to go back to the court for anything else, namely the sale of Denaxe's assets. So quite how it's suggested that there's some obligation in relation to all of this was and is lost on me. In fact, it's quite the reverse, we would suggest. We then come to...
where is the actual order?
The actual order is in tab 1 of the supplemental bundle.
So you're saying that the order in tab 1 of itself gave the receivers the power to do what they did without going back to court?
Of course, their whole raison d'etre and purpose is to sell assets. And if you look at paragraph 2 of the, paragraph 1 of the order, gives them vast powers to collect, get in, take possession of assets. All contractual rights, all steps reasonably necessary. F, sell, transfer, everything else. So that's the power that they have, because that's their whole purpose, is to get in assets and to sell them for the best price reasonably obtainable pursuant to their tortious duty of care. But there's a slight there's a slight addition to that in paragraph 18 of the order on page 8, which is in relation to one particular asset, which is not the assets we're concerned about here. It's only Mr. Oyston's 1.6 million shares in Denaxe. The court is to come back, and I think it was suggested, I expect that's right, that it was because it was arose out of the section 994 petition and so on. But there's no such obligation in relation to all of the other receivership interests, which are all against Denaxe, which are paragraphs 2, 3 and 4 of the schedule on the very next page, the annex. It's only in relation to paragraph 1 of the schedule, which is Mr. Oyston's shares in Denaxe, which have never been, which have never dealt with. We've got them back. That's why we're back in control of Denaxe. So I don't follow the point that there was some obligation to come to the court. Then we have, going back to the judgment at tab 15.
So what did the judge mean when he said, use the word required?
Don't know.
So he took a different view from the one you're putting, I think, at paragraph 41.
Well, what he said was, at paragraph 40, Mr. Collins suggests that this provision doesn't apply. Strictly speaking, he's right about that. Well, I was right. I mean, it doesn't apply. However, 41, however, the fact that technically speaking, paragraph 18 doesn't apply to the assets of receivers is, to my mind, missing the point. The existence of paragraph 18 underlines a wider point that I regard the sale of the club as a matter requiring court scrutiny. Well, there is no obligation, there's no requirement for court scrutiny, save insofar as it then goes straight into Nortel, momentous decision, and that's something where he is happy to provide court scrutiny and to provide a degree of immunity. The degree of immunity which follows from public trustee and Cooper, which is breach of fiduciary duty and can't impeach the transaction. But there's no separate requirement. The next passage, we go, I think, right to the end, because my learned friend majored upon paragraph 70. And I mean, the whole case is predicated on Nortel. And we go to paragraph 70, which my learned friend highlighted, but I rather highlight paragraph 71. Applying the criteria laid down in Nortel, I must ask myself whether the exercise of the power by the receivers that they propose to exercise is a lawful within the scope of the powers conferred on them by my order. Clearly it is. The order is drafted expressly to entitle them to get in and sell the assets that they're proposing to sell, having got them in. That's but a reference to the receivership order that we just looked at tab 1 of the bundle. 72. Have the receivers acted as ordinary and prudent reasonable receivers? Am I satisfied, without seeking to second guess the receivers, that the sale of the club to bidder 1 that they advocate is a proper transaction in all the circumstances? And proper means on the Nortel basis, within the power and all the rest of it. That's plainly what the judge was addressing in my submission. And rightly so, because it doesn't go any further. And it is not and I will submit that this is not the occasion to extend the immunity conferred by public trustee and Nortel, which is strictly in relation to breach of fiduciary duty and immunity from challenge to the decision and challenge to the transaction, to everything, to tortious duties of care, which plainly don't arise in public trustee and Cooper because those trustees don't own tortious duties, and to extend it in the way that was done, it goes right up, bang into all of the points that are made in insolvency law, which is that these highly paid professionals need to get on with it and take commercial decisions and not be second guessed, which is exactly what the judge was saying in this case.
But what is he doing in paragraph 73? It's been achieved, bidder 1 has been achieved after a competitive process. I'm satisfied the price is a reasonable one and not simply on grounds of price, it's the best bid.
Well, I dare say that, and I hope I'm not putting thoughts into my Lord Justice Snowden's mind, that if, when he had been asked to approach this
job.
That's what we've been enjoying.
If what what Mr. Justice Snowden had, when he was asked to approach this matter, to approach the Nortel matter at the higher level of public trustee and Cooper, had nevertheless had a bit of a sneak look into some of the vast agreements that were there and saw some absolute howler that they got the parties wrong or something, he might have said something and just said, I know I'm not really meant to get into all of this, but there's been a bit of a cock-up here, and I think you'll want to sort this out before I give a blessing to it, because I'm not happy to give a blessing to this extent. And so I dare say that if the whole thing had been sold for £1, this judge might have said, yeah, I'm not sure about that. But otherwise, he was just being asked what he was asked to, clearly being asked what he was asked to do, and to identify as against the transaction which was being mooted, only the terms of which were given, not the whole agreement, that was what he was actually sanctioning. That's what he was getting into in my submission, and not giving blanket approval. As a point was made, with which I respectfully agree to my learned friend, that if you're going to seek immunity, you ought to make it pretty clear that that's what you're doing, i.e. blanket immunity, as opposed to this sort of limited high-level immunity. And that not only concentrates the mind, it also just brings into play that that is not what you should get unless there are exceptional circumstances. We've not been able to find a case of such exceptional circumstances where these commercial decisions are second-guessed. And this was just the sale of some assets, nothing special about it.
Well, no, I mean, the point is he's making, he says not simply on grounds of price, but on the other grounds I have referenced. I mean, is he not talking there about, for example, the identity of the bidder as somebody who who's got an affinity for the club and wants to buy, as it were, everything together? It's a package. That's what bidder one really wanted. He's a local man with an affinity for the club, etc., etc. And he set that out in earlier on his judgment. So there are other factors, of which the critical one is he's not just going to sell it all as he wants to buy the whole thing. I mean, what's left of your points of claim, which is the point you need to deal with. What's left with your points of claim is they should have sold these things separately.
No. What's left of I beg them with respect, what's left in my points of claim is they should not have sold these things together for the price which they got. I'm quite happy that they sell them all together for a proper price, or separately for a proper price, but they didn't. They did not get a proper price for all of this.
But
it was not the receiver's job.
I need to push on this. Why do you... But the reason you say it wasn't a proper price was because you don't have any other particulars of saying that there was something else wrong with it. It's that they didn't sell them separately.
They didn't sell them by reference to their individual values.
But there are no other suggestions as to what could have changed the price. It's just that.
Yes, indeed, it is the fact that the whole thing was depressed. I mean, what actually happened here was that this loss-making football club was sweetened by bunging in a whole load of really valuable assets. Actually, what happened, and these receivers' jobs was not to save. They weren't put in there by the Football Association or the Supporters Club to save football in Blackpool. They were put in there to get the best value, the best price, reasonably obtainable on a tortious duty of care for these assets, and they were completely dazzled by saving football in Blackpool. And neither, frankly, was the learned judge's job to save football in Blackpool. It was to scrutinise the receiver's duty of care. And however he may have dealt with various things about football in Blackpool, and I've had a little look and it looks all right to me. The plain thrust of the submissions that were made to him, as we have seen from looking at as we've seen from the materials, and especially looking at the transcript and the judgment where he relies on Nortel, and paragraphs 71 and 72 is its classic Nortel.
So Mr. Oyston was in fact pursuing precisely the same negligent course of conduct when he, as he says in paragraph 6 of his witness statement, said that he was trying to sell the club and the football-related assets after the judgment of 2017 in order to discharge the judgment debt.
Nobody's suing him for negligence.
No.
Totally irrelevant.
But that was the picture in front of the judge, as the judge recorded, was that Mr. Oyston was there and didn't say, goodness me, you shouldn't be seeking to sell this all together.
The picture before the judge and in relation to Mr. Oyston's representation before the judge was that an application was being made under Public Trustee and Cooper as applied by Nortel, and we had no objection to the immunity afforded by Public Trustee and Cooper and Nortel, namely that hereafter there would not be a claim for breach of fiduciary duty, and hereafter there would not be a challenge to the sale to Mr. Sadler. But we reserved our position in relation to professional negligence on the part of the receivers, and that was absolutely right and proper. As your lordship said, that picking up my learned friend, we're not. It's not helpful to look at immunity per se. It's appropriate to look at what the court was being asked to do. Your lordship's more nuanced approach, and what the court was being asked to do here was to apply Nortel, MF Global and Nortel, and that's what it did, and that is what we in fact, to begin with, it wasn't even being asked to do that. What it was being asked to do was simply for there to be a permissive order, primarily directed at VBFA, so that VBFA's shareholding could be sold with the receivers, the assets over which the receiver. That was the thrust of the whole thing. And then very late in the day, Stevenson Harwood, 3 clear days before the hearing, starts going on about, well, we wanted actually to be on the terms of the terms of what's in Mr. Cooper's witness statement. Well, fine, it's got to be on some terms, just like your lordship's compromises in Nortel. You weren't being asked to sanction something in a void. Oh, look, you know, might like to enter into all this. You'd say, well, where are the agreements? I'm not just sanctioning something in a void. I'm not going to go into the agreements unless I see an absolute horlicks. But that's got to be before the court, so that the court actually knows what it's being asked to do in the context. But it's absolutely clear that what was being asked here was absolutely pure Nortel. That's what was being asked and what the judge did. In fact, he might have freelanced a bit around the evidence. Is frankly neither here nor there. What then happens is, and my learned friend took us to this, is if we go to the learned judge's judgment below, and this is where it all went wrong. Nothing's gone wrong so far. There's nothing wrong in my submission with Nortel, although it is as it were, a new application of public trustee. First time I think that public trustee in Cooper has been applied in that context, because MF Global is slightly different. But absolutely nothing wrong with that in my respectful submission. And I'm not just saying that because the judge is in front of me. But if we go to the judgment of the learned judge, and then he applies it all absolutely appropriately, where things go wrong is at paragraph. It's on page 17 of the bundle. First of all, there's the equating of equitable duties with tortious duties, because the judge is talking about, in the first 3 lines of paragraph 88, powers. That's all about pure Nortel. It says nothing about negligence. But what then goes wrong is at 90. First, the answer to Mr. Collins's warning, blah, 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 is this. First, precisely because the approval will prevent subsequent challenge, the court is cautious. Now, those words, prevent subsequent challenge, are in inverted commas because they pick up paragraph 83 of the judgment, and they come from Nortel. If you look at the penultimate line of paragraph 83, the consequence of approval being that it would prevent subsequent challenge. Now that's all well and good so far, but where this goes totally wrong...
Sorry, I'm lost the thread.
End of 83.
End of 83.
83, sorry.
Yes, paragraph 83. Because the prevent subsequent challenge is a term of art in the case that we're in at the moment, because it's your lordship's words in Nortel. And that's all fine if you understand it properly. The subsequent challenge that's being referred to in Nortel is absolutely pure public trustee in Cooper. It is a challenge to the decision on the basis of vires and to the transaction taken pursuant to that decision. That's what the challenge is. Not a complaint about it, it's a challenge to it. And where it all goes totally wrong is in paragraph 83. I can't imagine that Mr. Justice Snowden believed that immunity for Nortec administrators would be limited to claims that might be brought against them for breach of fiduciary duty, so that if the company or creditors alleged that the compromise authorised by the court was a negligent breach of their duty to obtain the best price available, i.e. total muck-up with the value of the subject matter of the compromises, rather than a breach of fiduciary duty not to prefer their interest, there would be no immunity as a result of the sanction of the compromise. Mr. Justice Snowden referred to the consequences of approval being that it would prevent subsequent challenge, and then these are the absolutely terrible words, in general terms. No, his lordship did not refer to them in general terms. He referred to them absolutely clearly in paragraph 50 by reference to paragraph 49, which his lordship, we have the benefit of him being here, picked me up on and said, well, you do need to look at paragraph 49 because that's what I was operating under, namely public trustee in Cooper, vires, rationality, and so on and so forth. It wasn't general terms, it was highly specific terms, and it has says nothing at all about negligent breach of duty. And that's where this has all gone terribly wrong in our submission. And yes, I think that's it. Unless there's anything further I can assist you with.
No, thank you very much.
Sorry, I
Mr.
ended in
Collins.
rather getting into rather a flourish, but there we are.
One shouldn't say this, but it was very appealing and entertaining, put it that way.
Increasingly entertaining.
No, there's nothing to be taken from
well,
those words that I use, of course.
We're much obliged to you all.
But I must thank you and everyone who has given such helpful submissions before the court, and everyone who's helped to prepare those submissions and to assist us in this interesting and difficult case. And so we're now going to give judgment. No.
I thought it'd be 10:30 tomorrow, Maria.
Okay. No. Obviously, this raises some very interesting and difficult issues, and it's important to take time to consider it properly, and we will do so. In the usual way, judgment will be handed down, in fact now, the usual way is electronically, and therefore you won't be required to attend. You'll be fully aware also that in relation to the order, we always hope that you'll be able to agree an order, and if not, you should submit short submissions in relation to the order. In relation to the judgment itself, as you will also know, it will go out, judgments will go out in draft, and you'll be, I hope, acutely aware of the issues in relation to confidentiality and embargoes, and the people to whom it should be circulated, their emails will already have been provided to our clerks, and it shouldn't go beyond that. And so I don't think there's anything more to add other than genuinely to thank you all, and to thank you for, which is what I meant earlier, the spirit in which these difficult and complex matters have been dealt with today. So thank you so much.
We're much obliged to you all.
All right.